Hey, I'm Alex Vail. I'm the managing attorney of the law office of Alexander R. Vail. I've been an attorney for 6 years. I'm licensed to practice in Florida and Nevada. I focus exclusively on immigration right now. I focus on family-based immigration, naturalization, and removal defense. So, to immigrate on the basis of a family-based petition, you have two routes available to you. You have what's called adjustment of status, and you have what's called consular processing, and I'll briefly describe both of them. Adjustment of status is the route where you complete all the necessary filing and you do the interview all here in the United States. Adjustment of status is limited to those individuals who have been inspected and admitted, which is a legal term of art for being admitted to the United States with a visa. Adjustment of status is a process that takes about a year. You submit a complete adjustment application with USCIS. That includes a number of forms. At a minimum, it's the I-130, which is the family petition. It's the 485, which is the adjustment of status. It's the 864, which is the affidavit of support. And there's the 944, which is the declaration of self-sufficiency. When everything's submitted to the agency, they're going to schedule you for a biometrics appointment. This is to confirm your identity and to check your background to see if there are any disqualifying crimes. About halfway through the process, if you elected to have us file the optional form, the 765, you would get a work authorization. And then about a year after filing is when you can expect to get your interview. The purpose of the interview is twofold. In all cases, it's to assess admissibility. So to obtain permanent residence, you as the applicant have the burden of proving you're admissible to the United States. And what does that mean? There are 10 general categories of inadmissibility, each of which break down into several subcategories. It's the applicant's burden to prove admissibility. There are 10 general categories of inadmissibility, and each of those 10 categories breaks down into several subcategories. My role is to make sure that the filing we submit to the Department of Homeland Security, Citizenship and Immigration Services contains all the evidence that the agency needs to find that you've met your burden of proving you're admissible. The second purpose of the interview is if it's based off a marriage, it's to prove the bona fides of the marriage. And that means that the agency needs to be satisfied that the non-citizen married the citizen or permanent resident spouse with the intent to form a life together. It was not solely for the purpose of obtaining permanent residence. So the documents that help establish that are documents that show that you own property in common, that you're leasing property together, that you have joint bank accounts, photographs together. These types of documents help to show the agency we have the intent to live our lives as a married couple. Assuming the agency finds that the applicant's admissible and that he or she merits adjustment in the exercise of discretion, permanent residence is granted. So that, in a nutshell, is the adjustment of status process. Consular processing is a bit more complicated. There's more moving parts. You're dealing with multiple agencies. I think the best way to explain the consular processing route is to divide it into 3 phases. So the first phase, the easiest phase, is the family petition. Again, I focus on family-based immigration, so there needs to be a basis, a sponsor, a petitioner that is a parent, a spouse, or a child who is submitting that petition on behalf of their loved one. So that first phase, the agency needs you to establish that you have the status that's required to petition. So permanent residents can petition and U.S. citizens can petition. And then you have to prove the necessary qualifying relationship. So if it's a parent-child relationship, the birth certificate generally proves that. If it's a spousal relationship, you need the marriage certificate in addition to what's known as the bona fides of the marriage. So as with adjustment of status, with consular processing, when you're doing this first part, the I-130, and it's based off a marriage, you want to make sure your filing includes evidence that shows that you two married with the intent to form your lives together. So phase one in this three-part framework that I set out ends when the Department of Homeland Security, Citizenship and Immigration Services approves the I-130. Phase two is when the Department of State National Visa Center receives the case. It informs the applicant and his or her attorney that it is ready to process the case for the immigrant visa. So that involves submitting the DS-260, which is the immigrant visa application. It involves uploading the affidavit of support and all the supporting documents. And really quickly, what that means is that the petitioner has the burden to show that his or her household meets a certain income threshold. That income threshold is set out, it's revised every year. It's referred to as the poverty threshold as set out by Health and Human Services. There's actually a form you can reference. It's the I-864P. It can be found on the Homeland Security, U.S. Citizenship and Immigration Services website. And if you don't have the necessary income, there are other ways to get around it. For example, by presenting assets that can meet that shortfall. But there is a formula that you have to use in order to satisfy the requirement based off assets. So phase two would conclude when the National Visa Center sends us correspondence indicating that it's received all the documents it needs to schedule the case for an interview. Phase three is when that interview is finally scheduled. Now you're going to be dealing with the U.S. Embassy or consulate in your native country that's going to be processing the case, that's going to be finalizing the case. So that's going to involve the non-citizen, if they're not already in their native country, returning to their native country to complete the interview. And there's a medical exam they'll have to undergo. Again, the purpose of that interview, as with adjustment of status, is to assess admissibility. So whether you're seeking to adjust status, whether you're seeking to immigrate through consular processing, you as the applicant have the burden of proving you're admissible to the United States. The purpose of the DS-260, which you complete in phase two, and the purpose of the affidavit of support are to help overcome several of these grounds of inadmissibility. At the interview, they'll go over that information and they'll verify and confirm that you as the applicant are admissible for permanent residence. You'll receive an immigrant visa packet, assuming you're granted the immigrant visa, and with that packet, you'll be able to immigrate to the United States. The consular processing route takes a relatively long time, and it depends on the country of chargeability. So then that means it's going to depend on what country you're immigrating from. Some countries have larger backlogs than others. For some countries, you'll get interviews quicker. In my experience, I've noticed that the longest lag is in waiting for that interview to get scheduled. So how I explain it to my clients is as follows. When the ball is in our court, we do everything we can to put it back in the agencies. We will get the filings that need to get done completed and submitted as soon as possible, because we know that there are already long wait times that you can't do anything about, and so we do our best to mitigate the overall wait time by cutting short the time period in which we're holding on to documents, we're holding on to information that we need to submit to the agency.